by supplementary list. Item number 1.
May I please, Your Lordship?
Yes, yesterday's matter.
Yes, my lord.
Yes.
Yes, my lord. My lord, the petitioner herein come before this honorable court by filing a miscase, my lord, in WN number 52 of 2011, disposed of, white order dated 2/11/2017, my lord.
Appeal is disposed of.
Appeal disposed of in the year 2017 with the direction to constitute a 3-member committee headed by the Chief Secretary, the Government of Meghalaya, to hear the grievances of the tainted teachers, my lord. The instant issue germinated in the year 2008, my lord, in the advertisement wherein the petitioner herein had participated in the recruitment process, and thereafter he had selected in the recruitment process in the interview, but unfortunately he was not appointed in that recruitment process. Thereafter, in the year 2011, he was appointed as assistant teacher, contractual basis, my lord. And throughout the year, he is continuing in his service, and his service was extended and renewed from time to time by the state government. And in the year 2023, 1st of July 2023, his service was terminated on the ground that he is tainted candidate who participated in the recruitment process held in the year 2009, my lord. So, in the judgment,
Yes.
by judgment dated,
Why they are called tainted teachers?
my lord, when the recruitment process, after completion of the recruitment process, total 76 candidates were appointed by the state respondent in Tabengri subdivision, my lord, in West Garowe. Thereafter, my lord, unsuccessful candidate come before this honorable court with a batch of petition, and CBI inquiry was conducted, my lord. And in the CBI inquiry, my lord, in the CBI inquiry, they have found the use of white eraser in the result sheet and in the answer sheet, in the mark sheets. So, in that report, they have made tainted, my lord. They have used the word tainted candidates. So, though I have participated in the recruitment process, I was not heard throughout the proceedings, my lord. I have not participated in the proceedings. Neither I have issued notice to me by the CBI or any other agencies.
But appointment was given.
I was appointed in the year 2011 as contractual basis teacher, my lord, not permanent teacher, not through that recruitment process. A separate one, my lord, I was appointed, my lord. My lord, kindly have an appointment, my lord, at annexure, my lord.
No, but what was the subject matter of the writ?
Subject matter, my lord, my only difficulty, my lord, as per the judgment dated 2/11/2017, 30 days period time limit was framed by the judgment to file a representation before the 3-member committee headed by the Chief Secretary. Now,
Now, what was he to inquire into? What was the committee to inquire into?
committee has adopted a criteria and
Those teachers who were irregularly selected,
Yes, ma'am.
were they appointed or not?
no, their service has been terminated, my lord.
Service is terminated.
Terminated, my lord.
Now, this committee is for what purpose?
This committee is to hear the grievances of the candidate or of the assistant teacher who were declared tainted, my lord.
That means service terminated.
After termination of the service,
They were recruited in 2011.
they were recruited in the year 2009, my lord.
Okay.
I am not the, I am not,
Those vacancies are there or filled up now?
those vacancies, my lord, were filled up recently in the last year, another recruitment process, but I am not part of all of it, my lord. Though I have selected in the year 2009 in the said recruitment, I was not appointed. I was appointed thereafter in the year 2011 on contract basis. I was serving as contractual basis teacher. Due to the termination order, my lord, on the basis of tainted candidate, my only humble prayer before your lordship is, allow me to file a representation before the 3-member committee. And
What is the 3-member committee supposed to do?
my lord,
What is the what is the jurisdiction of this committee? What is the function of this committee?
This committee will decide, will look into the entire aspect of the candidate who filed or the assistant teacher who filed the application representation with regard to the recruitment held in the year 2009, whether there is a interpolation or manipulation in their answer scripts. If they found tainted, again after scrutiny, there is in the said judgment, they can impose 50,000 cost and permanent debarment from government service, my lord. That is the
And if not, then?
and if not, those who were appointed in the year 2011, they were appointed, my lord. In some 187 teachers in the entire Meghalaya, they have filed a representation after passing of the order of this honorable court. They approached the three-member committee, they filed representation, and thereafter, my lord, after scrutiny of their entire records by the three-member committee, 187, they have adopted a formula, they have created a formula and procedure in that 187 were again reappointed, my lord. But I am not for the appointment, my lord, so that my future employment, future scope will be open, my lord. I am out of the service now. My only grievance is there is a stigma on me, my lord, because of the declaration of the tainted, my lord. I am come before your lordship.
How is stigma against you? You are the contractual appointee of
My lord,
2009.
because of the tainted, my lord, my service has terminated. My future employment will be blocked, my lord. I am not able to any employment, my
So
lord.
there is an allegation that your selection was also tainted.
As per the CBI inquiry report. But it is a squarely covered case, my lord. There is a total 5 orders, my lord.
Your Lordship,
Yes, Mr. Advocate.
the one thing, my lord, that has been suppressed from this honorable court, that the petitioner approached the learned single judge on the same set of relief. That was dismissed. Against that, writ appeal was preferred. That was also dismissed. Not a single word in the entire petition. Your Lordship, kindly see these 2 orders passed in this case, my lord. My friend should have disclosed this material fact, and he has not disclosed, my lord. He has suppressed this fact, my lord.
My lord, that is with regard to the year
Your Lordship,
2000.
kindly see that detail should have been the order of the learned single judge, my lord, dated 20th November 2023, my lord. Petitioner here, he is the Ainul Haq, my lord, the petitioner before your lordship. Petitioner herein being aggrieved with the termination of their services as contractual teacher on 1st July 23 had earlier approached this honorable court by way of writ petition number 253 of 2023 and writ petition number 266 of 23. This court then by order dated 22nd August 23 passed in both the petition, disposed of the writ petition by allowing the writ petitioner herein to file representation against their termination. Thereafter, petitioner accordingly had preferred their respective representation, which had since been disposed of by respondent number 2 by speaking order dated 26 September 23, wherein reasons have been given as to the termination of contractual service. Mr. Kurasi, learned counsel for the petitioner, has strenuously argued that there has been no adverse remark against the petitioner and they have been serving with effect from 2011 and 2010, and the reasons given by respondent 2 as being tendered in the selection process held pursuant to advertisement of 10 December 2008 is without any basis. This is submit that is because they were never afforded appointment pursuant to the being selected by the said process. They have been declared to be tainted. Their contractual employment being independent of said selection process, rejection order is submit is therefore arbitrary and illegal and liable to be interfered with by. Learned AG has refuted this submission and has contended that impugn order of rejection is well written and based on substantial material. Petitioner he submits having been declared tainted by CBI inquiry on direction of this court, to which they never represented, in spite of being allowed the opportunity, cannot at this stage seek relief. It is further submitted that as per order of this honorable court dated 2nd November 2017, services of all tainted teachers are to be terminated forthwith. Having heard the learned counsel parties and perused the material, it is to be noted that representation of petitioner have been exhaustively dealt by respondent number 2 wide order dated 26 September 23, which has been impugned herein, and extracted of the order is relevant. A, B, C, D, both the petitioners will, and bottom your lordship will find, subject to proviso that only candidates who have been treated as untainted, unblameless, both in report of CBI and HLSC and are in service may be allowed to continue as a stopgap arrangement until fresh selection takes place, and the services of all tainted teachers are to be terminated forthwith. Honorable High Court, while order dated 2nd November 2017 under 1D of conclusion and direction of the order, state that none of the candidates who has been found tainted, blameless, whether in report of CBI or in the HLSC or both, as also none of the candidates who have been recommended by public representatives shall be taken or retained in the service, even in a stopgap arrangement, and services of every such candidate who is yet continuing, whether by way of regular appointment or in ad hoc arrangement, shall stand terminated with immediate effect. A perusal of impugn order reflects that termination is not without reason, has been passed considering the entire gamut of the matter and claims of the petitioner being examined and dealt with in view of the matter, therefore being no ground made out. And then, my lord, against this, petitioner approves before your lordship by way of writ appeal, and that was also, your lordship will see the second order passed on 14 February 2024. And the facts are same facts, my lord, which learned single judge has recorded. And at paragraph 6, the writ appeal has also been dismissed. Lord, none of these material facts have been placed in the MA filed by the petitioner before your lordship in the present year. And recently, my lord, there is a recent judgment of the Honorable Supreme Court which says that this practice has to be deprecated when material facts are not being disclosed, and the case application was dismissed with the cost, my lord. May I place this judgment of the Honorable Supreme?
That is very well known. That
Yes,
suppression of material facts
and my lord,
entitles to
this is on the suppression. So far as the on merit is also concerned, my lord, the order of the division bench, my lord, your lordship may kindly take note of 2 paragraphs only. Paragraph 3, the earlier legal position is there, my lord. Paragraph 3, paragraph 4, my lord, and 5. And 6, these are the. It was the duty of the petitioner to disclose all these material facts before this Honorable Court, my lord, because he has already approached the learned single judge against the order of termination. First round, he was given opportunity to make the representation. That representation was exhaustively dealt by the government. Then he filed writ petition challenging that order. Writ was dismissed, my lord. Thereafter, writ appeal was also dismissed, my lord. And none of these material facts have been disclosed, my lord. And the liberty granted by this Honorable Court to make representation to 3-member committee was of order dated 2nd November 2017, my lord. And that representation was required to be submitted within a period of 1 month, my lord. My friend is here seeking modification of that period of 1 month time so that he can make the representation, my lord. And all along he has been aware of this order of 2nd November 2017. At no stage he made any such representation, my lord. And you also will see that direction at page 47, my lord.
This is a miscellaneous application in this appeal.
No, my lord. In the disposed of appeal, WA number 52 of 2011.
That is of dated, my lord, 2nd November 2017. Writ appeal, what the factual matrix is, my lord, that in 2008, recruitment process was initiated for for appointment to the post of primary school teachers. Large scale malpractices were noticed. The division bench directed CBI inquiry and termination of services. Wide order dated 2nd November 2017, my lord. Division bench also said that those have been declared tainted in the CBI report or in HLSC report, they will have one more opportunity of making representation to a committee of 3 members within a period of 1 month from the date of the order of the division bench dated 2nd November 2017. Now, MA is being filed in that order saying that now please extend the time of 1 month so that I can make the representation now to the committee. That is the MA before your lordship. Before that, what my friend argued, my lord, that he was appointed as contractual teacher in 2011 and his services have been terminated into 2023. But he did not disclose that he challenged that termination before this honorable court by way of in the writ petition. That was dismissed. Writ appeal was dismissed. All those material facts have not been disclosed. So in my humble submission, this application is also not maintainable, and on suppression of material and facts also it is not maintainable on both on merit as well as on suppression, my lord.
May I please, Lordship?
Yes.
My lord, this is squarely covered case, my lord. My lord, what my learned senior advocate AZ has submitted, my lord.
Mr. Advocate General, these posts have now been filled up.
Yes, my lord.
Filled up, my lord.
And they are all unqualified because the NCT, National Council for Teacher Education, my lord, has made a mandatory requirement that you should be qualified, MTET qualified or TET, Teachers Eligibility Test, you should qualify. And they have earlier also approached this honorable court, number of teachers whose services have been terminated because they were not qualified. They filed various writ petitions, my lord, challenging those requirements, and that those have been dismissed by this single judge, by division bench also. But this fact, material fact is also not disclosed, that he is also not qualified candidate in terms of requirements laid down in NCT, my lord.
My lord, with that short reply, I am not come before your lordship for seeking any job, my lord, for seeking any service, my lord. My service already gone, my lord. I only come before your lordship, my lord, with a limited prayer to allow me to file a representation before the 3-member committee as per the judgment dated 2/7/2017, and my case is squarely covered case, my lord. This honorable court has on 5 occasions, this honorable court has allowed the same extend the same benefit to the other tainted teachers, my lord. Those who were appointed and
Regular appointees.
those who were regular appointees and their service had been terminated. And with regard to the judgment, which I have not come before prior to on time, because, my lord, I am not the beneficiary of the recruitment in the year held in the year 2009. And I am not the part of the proceeding of the WA number 52 of 2011, my lord. My lord, only a limited prayer. My lord, kindly have, my lord, annexure 6, my lord, at page 53, my lord. Annexure 6, my lord, at page 53, my lord. If my lord allows, may I read, my lord? From page 52, my lord, the direction, my lord. In the same way, this case has been, this is a writ petition, my lord. Writ petition number 195 of 2020, my lord. All Meghalaya Primary School Teachers Association and 254 others, my lord. In the white order dated 22/09/2020, my lord. Page 52, may I read, my lord? The petitioners are at liberty to file representation before the committee headed by the Chief Secretary, Additional Chief Secretary, Government of Meghalaya, full stop. Such representation shall be filed within 30 days from today for considering them as untainted teacher, my lord. The committee headed by Chief Secretary, Additional Secretary shall examine the petitioner's representation as per direction contained in para 2 of operative part of the order in WA number 52 of 2011 and shall take decision on such representation within a period of 60 days from the date of receipt of the representation, my lord. On 5 occasions, my lord, Jaintia Hills Association and from Dadangiri also, my lord, those who were appointed and served and their service were terminated by the judgment dated 2nd November 2017. I am not part of all of it, my lord. My lord, I was selected in the interview held in the year 2009, my lord. my only last opportunity, my lord, to file a representation before the committee headed by Chief Secretary. If the committee, after scrutiny of my entire case, if they found tainted, they impose cost on 50,000 as per judgment dated 2nd November 2017. Thereafter, my lord, another order, Annexus 7, my lord. The same, my lord.
That order we can pass. Yes, please take it. First of all, there is a long delay of about 7 years in preferring this application. Secondly, the special committee appointed by this court to inquire into tainted appointments of school teachers had the jurisdiction to make an inquiry with regard to the recruitment process for appointment of regular teachers, initiated by the government in 2008. Full stop. It had no power or jurisdiction to make an inquiry into the legality of appointment of contractual teachers. Of whom the applicant is one. Paragraph. The inquiry is long over. Full stop. The posts of school teachers, as submitted by the Learned Advocate General, which became vacant after cancellation of the irregular appointment process, have been filled up. Full stop. It may be mentioned now that according to the order passed by this court appointing the special committee, if the committee found an appointee to be unblemished or untainted, he could be appointed regularly. Full stop. Hence, there are no posts of school teachers now to be filled up. Paragraph. However, since the appointment of both contractual and regular teachers were questioned and declared to be tainted, comma, for any future appointment, the applicant has some right to claim and to be declared that his appointment as a contractual teacher was regularly made. Full stop. In that view of the matter, we do not allow the prayers made in this application, but we direct that the special committee constituted by this court will look into the appointment of the writ petitioner and make a decision within 2 months of communication of this order as to the legality of his appointment as a contractual teacher in 2011. The applicant shall be free to take part in any future recruitment process if found eligible, and be considered accordingly. This application is accordingly disposed of.
My lord, with a small, my lord, correction, my lord, with regard to the not appointment of the contractual teacher, with regard to the issue of tainted and untainted, my lord, the scrutiny committee has to decide on that, my lord, not with my appointment. I am already out of my service, only to regard to the tainted and untainted.
Whether your appointment was tainted or not, that's all.
That's all, my lord.
That we have said that.
My lord, highly obliged. Keep your blessing.
From the daily list, item number 1.
Yes.
May please, Lordship. Lordship, in terms of the last order, I filed one small report annexing photographs, my lord. If my lord may kindly see photographs starting from page 3 onwards.
Yes.
My lord, we have just received the report from learned amicus, my lord. What I am praying is that, my lord, another
Who is the amicus?
My lord.
is the amicus.
Who is the petitioner?
Petitioner is deceased, my lord, and this PIL was registered on Suomoto, registered, my lord, as PIL because of the bad road conditions prevailing in Joy Ratachara stretch of road of the National Highway, my lord. Then I represent the National Highway authorities, my lord. The construction and repair work is going on, my lord. So I'm praying that to show significant progress, another 3 months' time may kindly be granted to us, my lord. Work is still going on, my lord, but to address the entire stretch and the damaged portions, my lord.
So he has said that although stated to be going on, nothing is noticeable to be going on.
No, that is factually incorrect, my lord. Today also I'm having.
My lord, can you look at the photographs? How the vehicles are, my lord, stuck in the middle of the road. My lord, can you come to page 4? Page 3 first. Then page 4, my lord.
My lord, in the previous months, my lord, till September, October, my lord, there was heavy rain, landslide, and everything was occurring, my lord. The National Highway authorities has deployed all the machineries, my lord, to address these issues, my lord.
Page 3.
Yes, my lord. Page 3 onwards, my lord. Of my report.
My lord, we also have prepared a status report of our work which is going on, my lord. May I please, my lord?
Protestants, they don't want it to be done.
My lord, page 4 onwards is the photograph, my lord. The bituminous work, the drain work, the pothole repairs, protection wall, everything is being attended, my lord. My lord, to completely remove all the damaged portions of the road, my lord, we need some more time, my lord. I'm praying if the matter can be listed after
It is repair or construction.
repair, my lord.
The road is there.
The road is existing road, but it gets damaged due to heavy rain and landslide, my lord, at certain stretches, my lord. So we are attending, and on the last
No, my
of
lord. This is completely, my lord, in respect to different road, my lord. Not the road which I have pointed out in my report, my lord. This is completely different road, my lord. Of course, the stretch is same, but these stretches are totally different, my lord.
No, but it might be, what is the length of this stretch which is badly affected by water and flooding, etc.?
This total, my lord, in total is 45 kilometers. But here,
What is the total length, Mr. Sengupta?
102 kilometers, my lord.
You are Mr. Sengupta.
Yes, my lord. 102 kilometers, and my lord, even it is reflected on the last occasion on the
So
order.
how many kilometers done already?
My lord, bituminous work, 2 kilometers, drain construction, 7 kilometers, my lord. Then, my lord, several locations, breast walls, protection walls have been constructed, my lord. My lord, in my report of today's report, my lord, page 2 onwards, my lord, the detail has been also provided, my lord. Because of the severe monsoon rain, my lord, our work also could not progress at a faster pace, my lord. Now that we are getting a dry spell, my lord, we are trying our level best to attend to all the. In fact, my lord, the contractors have been given 1 year timeline to complete their work, my lord. However, my lord, we are putting pressure on the contractors to expedite the work as at the earliest, my lord.
What is the utility of this highway?
My lord, this connects this, the states like Tripura, Mizoram, and other connecting states, my lord. Through this stretch of road, the vehicles move, my lord. It's very essential.
And connect up to the highways of Tripura, Mizoram, etc.
Yes, my lord.
Passes through that road, my lord.
It passes through or it
Through, my lord. Passes through this road.
it covers Tripura and Mizoram.
Yes, my lord, it connects. It also goes to the part of Assam, my lord, Silchar and Kachar, my lord. So this is a very vital connection road, my lord.
No, so this
Page 2, my lord, bottom, my lord.
NH6.
NH6, my lord. Right, my lord. May I read the bottom part of the page 2, my lord?
Yes.
This road connects to the adjoining states like Tripura, Barak Valley of Assam and Mizoram, and the traffic flow is very high, which is also not conducive for the speedy repair work, since the vehicular movement of traffic cannot be stopped, and as such, all repair work has to be managed, keeping in view the management of traffic, my lord. Of course, my lord, we are trying to adjust both the traffic flow as well as to attend to our repair works, my
So
lord.
how many kilometers is this?
102 kilometers.
In total, my lord.
And 2 contractors have been given, my lord, the work, both 51 and 52 respectively, my lord.
So out of 102, the total length is damaged or part of it.
Roughly
No,
about 45, my lord.
Certain portions of the roads got damaged, my lord, because of the heavy monsoon on the last few months, my lord. There were heavy landslides, my lord.
But only 2 kilometers have been attended to up to now.
Up till now, my lord, 2 kilometers of bituminous work, my lord.
That is the road
Yes,
height,
my lord.
sir.
Because in certain portions, my lord, the drain also needed to be attended, because if the drain is not prepared, my lord, then all the water flows over the road and it damages the road, my lord. So the drain work also is simultaneously being carried out, my lord. And in certain stretches, my lord, the road got damaged and washed away due to landslides. So protection wall also has been carried out, my lord.
At least for now, my lord, what I would humbly pray, these road, my lord, which I have pointed out in my report, at least, my lord, temporarily, some measures may kindly be taken, my lord, at least to refill these big portals, my lord.
Traffic cannot move in those areas.
It's difficult, my lord. My lord, kindly see, my lord, from page 3 onwards.
My lord,
What area is that? What is the length of that?
My lord, in the report, my lord, the locations has not been specified, my lord.
It's Umgyang, my lord. It's Umgyang. Exactly, my lord, the location. It is Umgyang, my lord. In fact, I had sent photographs through WhatsApp to my valet.
What is the length? 1 kilometer, 2 kilometers, which are now not roadworthy. You have gone there, you have physically seen it.
I have not visited, my lord. I've taken the photographs from one of the residents, my lord, who is residing at Umgyang, my lord.
That will not do.
My lord, I'll send it to the authorities immediately, my lord. They will take corrective measures. Only thing is that the location, if had been provided, it would have been made easier, my lord, to immediately attend to, my lord. We will be attending anyhow, my lord. It is our obligation to do it, my lord.
The bad patches, my lord, roughly it will be about less than 5 kilometers, my lord.
Give them some time and. We have gone through the report of Mr. Suraj Panthi, learned amicus curiae. Suraj Panthi, advocate, learned amicus curiae, appointed by this court in this public interest litigation. The photographs which have been annexed to this report show some portion of National Highway 6 in a severely damaged condition, so much so that it is really impossible for vehicles to pass. Full stop. But the report does not mention the location of this portion. Full stop. Mr. Sengupta, learned counsel appearing for
National Highway Authorities.
NHAI, submits that if this location was indicated, he could have instructed his client to take
Immediate.
suitable measures. In that view of the matter, Mr. Panthi is requested to immediately inform the National Highways authorities about the location of this part of the damaged highway, indicating the approximate length of the road also. Paragraph. The subject matter of this public interest litigation is a stretch of 102.255 kilometers. Of national highways bracket NH6 between Jowai, Jowai and Ratachera.
Actually, my lord, this PIL is concerning Lumshnong to Malidor, my lord. This PIL, my lord, is concerning, my lord, Lumshnong to Malidor, my lord. Is
It
further.
will be included within that stretch.
Paragraph. This highway is a kind of lifeline for Meghalaya, Tripura and Mizoram. Paragraph. Further, to orders of this court, the National Highways Authority has also filed a report in this court. This report shows, the photographs of this report, however, show that extensive road construction repair and maintenance work has been undertaken by the said authority. The damaged portion as submitted by the learned amicus curiae out of 102.255 kilometers is about 54 kilometers.
No, my lord. The bad portions, my lord, roughly would be about 5 kilometers, my lord.
No, no.
4 to 5.
Wow.
The entire,
Entire.
45, my lord. 45.
45 kilometers. The very badly damaged portion, as referred to earlier, covers about 5 kilometers. According to the report of the said authority, two kilometers of the highway, of the said stretch of the highway, has been strengthened by undertaking bituminous work and comma, 7 kilometers of drains have been constructed and quotation reinforcement binding for 5 kilometers of drain construction, unquote, is in progress. Paragraph. We have no doubt that the National Highways Authority has every good intention to carry out our order, full stop, but we are constrained to remark that the pace at which the work is progressing is rather slow. In those circumstances, we direct that the very badly damaged portion of the section of the highway stretching about 5 kilometers, as stated above, should be repaired and reconstructed. Mr. Sengupta, how much time you will take to
My lord,
5 kilometers?
my lord, I'm praying for 2 months' time, my lord.
Within 2 months from the date of communication of this order, full stop. Within 2 weeks of communication of this order, some measures have to be taken so that, some emergency measures have to be taken so that till the regular work is carried out, the said part of the highway is pliable by vehicles, is reasonably pliable by vehicles. And the rest of the 40 kilometers,
My lord,
6 months?
6 months, by 6 months, my lord, it will be, we expect it to be completed, my lord.
Yes. The rest of the 45 kilometers should be completed before the start, well before the start of the rainy season. Well before the onset of the next monsoon. Within 5 months, within 5 months from date. Full stop. The authority should ensure that the work done is of such quality that it is not damaged by rain or other weather conditions in future. List this public interest litigation in the second week of May 2024.
Yes, my lord, we'll put in all our efforts, my lord, to complete it.
No, you list this public interest litigation on 16 December
For a status report, my lord.
or 11 December to ascertain the emergency work to receive an action taken report on the emergency work to be carried out in terms of.
Yes, okay, my lord. We'll ensure it.
Item number 3.
My lord, I am appearing for the appellants in this matter.
Yes.
My lord, this matter is a 37 appeal. On the last date, the LCR had been requisitioned by my lords. I was hoping for a date in the matter for final arguments in case reply is not required by my lords. If reply is required, then they have to file a reply in the matter.
The court has been received, my lord.
records has been received from the, my lord, commercial court. Lord, we have to scrutinize whether all the records have come or not, my lord. And my lord may fix the matter for you. Paper book may be prepared because otherwise, my lord, let the appellant prepare a paper book, file, and then matter may be fixed. Thereafter, matter may be fixed for final hearing, my lord. You have prepared any cross objection?
No, my lord.
No, my lord, no cross objection. No cross objection. We have in fact, my lord, so far the, my lord, principal and future interest, my lord, we have already paid the amount, my lord.
We have paid.
Entire 5 crore 74 4 lakhs and odd, my lord, we have already paid, they have received it.
So only the
Issue, my lord, with regard to pre-suit interest and, my lord, pending rate interest. That was, my lord, rejected by the, my lord, the commercial court on our appeal, my lord, under section 34. And against that, the appeal has been filed, my lord, here.
prepare an informal paper book, we will hear out.
That will be better, my lord. Let the appellant prepare a paper book, file it, my lord, and thereafter, my lord, later time we fix for filing a paper book.
Low court records have arrived.
Yes.
They have arrived, my lord.
Yes, please take them.
My lord, all documents relevant for adjudication on the appeal have already been filed by us in the appeal itself. Do my lord want the entire LCR to be converted into a paper book for my
No,
lord?
no, informal paper book. It will have an index.
No, all the documents are already part of the appeal, my lord, except the judgments we're relying upon. All of them have already been filed with the appeal as reporting.
Then why do we make a petition in the court? We can just hand up all the documents to the judge and say all the documents are there, you decide the matter. Why do we file a petition? You try to understand, the appeal has some form. In trial court there is a form, in the appeal court there is a form, there is a memorandum of appeal, paper book, all the papers are there, index is there. You must follow that, not that you hand up all the papers and say you decide the appeal. If this practice is being followed, this is only at the stay application stage it is good.
Very good.
You also know,
Yes, madam.
when an appeal is to be heard out, it is to be heard out on a regular paper book. But we are dispensing with all formalities. You prepare an informal paper book with an index which will have petition, affidavit, reply, impugned judgment, memorandum of appeal, etc. The petition with annexures, opposition with annexures, reply with annexures, memorandum of appeal, stay application, etc. It makes it convenient for the judge.
Very well, my lord. Convenience compilation, essentially, my lord is asking for. I
Please take
understand.
down.
Okay.
This appeal was admitted by the order dated 8th August 2024. Paragraph, the lower court records have arrived. Paragraph, we are minded to hear out the appeal, dispensing with all formalities. Paragraph, advocate on record for the appellant is directed to prepare and file an informal paper book with an index by
Now, 2 weeks would be sufficient for me to prepare it and file it.
all right, 20 November,
20th November. Much obliged.
comma, serving a copy on the advocate on record for the respondent at least 7 days before the date fixed for hearing of the appeal. List this appeal for hearing on
9th December.
Well, can it be, my lord, if not inconvenient to my lord, 11th or 12th December, my lord?
12th is a holiday.
Huh?
12th is a holiday.
Then 11th, my lord.
Why not 10th? 10th, 11th, we could have finished it.
My lord, the difficulty, my lord, we are coming from our station. My lord, we have heard that, my lord, there is a concert and all that, my lord, no rooms are available. Even today we wanted to book for some other matter for 10th. Hotels are not available here, my lord.
See, that is so much good for the state, for the High Court. That is why we also encourage physical appearance.
It will be always better to have physical appearance, my lord, because, my lord,
Our culture is that, our way of functioning is that.
my lord. I find also, my lord, ease in my lord, arguing physically, my lord.
Yes.
My lord, I was proposing, my lord, if not inconvenient to my friends, my lord, paying for the appearance. Can it be, my lord, after vacation, can it be taken up, my lord?
No problem.
My lord, let it be on 3rd of February, my lord.
What do you say?
It reopens on 26th, my lord, 27th January.
All right.
My lord,
Wait for hearing on 3rd February.
since it's a short issue, my lord, will my lord may put it before 10th also, my lord, if that is convenient to the court's schedule. If not, then February is fine. I will need about an hour to press arguments.
Let it appear on 10th December. If you have any problem, we will adjourn it till after the vacation.
All right.
List this appeal for hearing on 10th December. Any problem regarding whether hotel reservation, anything, you will let us know. We shall be very glad to accommodate you. But please come and do the matter here.
Well, true, my lord, we'll do it. We would like to do, my lord. It will be, my lord, our
10th December.
10th of December.
Much obliged.
Item number 3.
Right.
May please, Your Lordship. Lordship, in this matter, I pray for some accommodation, Your Lordship.
Why, what is the problem? Formal notice not served.
Yeah. We are waiting for respondent. We have 5 local number today. We entered appearance, maybe.
You're paying for adjournment.
Yes, Your Lordship.
We will file objection against the petition. We may be given some time.
In the earlier matter, was there any application, miscellaneous application? Only appeal. Yes? Objection to what?
Condonation petition they have filed. Condonation petition, delay of 63 days, 62 days in filing this appeal. This is case number 3 of 2024.
All right. Let affidavits be exchanged in miscellaneous case number 3 of 2024 according to the following direction. Affidavit in opposition by 20 November. Affidavit in reply may be filed by 29 November. List the appeal along with the application on 4th December. 4th December. After affidavits.
My Lord, my 8th Thakur, resisted by J. Ratna, may kindly be
Yes, yes, please. Certainly.
Much obliged, Lordship.
Please note down the appearance properly. Yes.
Item number 4.
Will please, my lords. Lords,
Yes.
this PIL, my lords, has been filed on basically 2 counts, my lords. One is for implementation of the animal birth control rules of 2001 that pertains to stray dogs, my lords, in Shillong. And the other is, my lords, with the implementation of the zoo rules for the, my lords, the animals that were earlier kept in a small park, which is known as the Lady Hydri Park, and they were being transported into the the new zoo which has been created. Now, the affidavits have been filed, my lords, by the state insofar as the park is concerned. Insofar as, my lords, the affidavit, there's a status report which has been filed by the Shillong Municipal Board.
You're the petitioner?
I'm the petitioner in person, my lords. I'm appearing in person here.
And I'm appearing on behalf of the respondents 1 to 3, Your Lordship.
Yes.
Well, it's,
We have filed an affidavit.
there is a report that has been filed by the Shillong Municipal Board insofar as implementation of the, my lords, ABC rules as they are called in short. Well, I've examined it. I would pray, my lords, your lordships grant me a week's time. I'll file a short reply because it seems, my lords, that these rules, even though they were implemented in 2001, effectively on ground, my lords, nothing has been done.
In both reply?
My lords, I file a short reply, my lords. Just
In each?
Yes, my lords.
Affidavit in reply may be filed by 20 November, list on 5th December.
5th of December.
No, sorry. Affidavit in reply is being filed 20th. List on 27th November.
Highly applied.
Right, Your Lordship.
In each.
Item number 5.
So this is an appeal by the Income Tax Department. Lordship, appeal is yet to be admitted, Lordship.
260A.
Lordship.
Any delay?
Lord, delay was condoned. Thereafter, Lordship, this Honorable Court directed the respondent to file their objection. Appeal is yet to be admitted, Lordship.
Objection to what?
Lordship, actually, this Honorable Court directed to file their objection. And there is,
Where are the questions of law?
Lordship, it page 7, Lordship. I have formulated to.
May it please, Lordship. Lordship, I'm praying for some accommodation in this matter for today. The conducting counsel, Mr. P.K. Sharma, he's having some difficulties, Lordship.
You see, for
On station.
admission stage generally, in these tax matters, no response is required. The court formulates the substantial questions of law. Only when the court needs assistance of the respondent, calls upon the respondent, you assist whether in the court deciding whether substantial question of law is there.
Lordship.
Generally not. So, if you want your senior to appear, we will adjourn the matter, but then, is it a very difficult question of law? It is a question of law.
Lordship, page 7, 1 and 2. Lordship, in this case, what happened? They didn't deduct that TDS from their customers on the ground that they are exempted from paying the tax under section 1026.
Suggested substantial question of law. You have made this.
Lordship, 1 and 2 will do, Lordship. That will cover the entire case, Lordship.
Who is making the payment to whom?
Lordship, they have to deduct that TDS from the customers. They didn't deduct the TDS from the customers on the ground that they are the tribal people. They are not liable to pay tax. But section 195 doesn't distinguish between tribal and non-tribals. They have to detect and file the certificate, lordship. But that was not done by the respondent, lordship.
So what is the consequence?
Consequence, lordship, we made addition in their final assessment, lordship. And lordship, this issue has already been dealt by the full bench of Tripura High Court. That is decided that if they while detecting the text, they have to detect and file a certificate to that effect. But nothing was done by the SCC, lordship. So section 195, the lordship, it not distinguish between the tribal and non-tribal people. And this question has to be decided by, it not been decided by any other High Court or by the Honorable Supreme Court, lordship.
Has not been decided.
No, lordship. Except one judgment is there of Tripura High Court full bench. It says that if they are exempted, they have to file certificate to that effect. Lordship, examine the issue.
You see, this is a nice question of law. So if he wants his senior to come and assist the court,
Lordship, no.
when?
After 2 weeks, lordship.
Why 2 weeks? Where does he stay?
He's from Guwahati.
Then why 2 weeks? Next week? you
The
come.
next week, lordship.
List this appeal for admission. List this appeal for further hearing for the purpose of admission. On 11th November 2024. But you are not coming.
So 21st, if you not inconvenience to your lordship.
Sorry?
21st November, lordship.
All right, 21st November.
Much of.
Item number 6.
May it please your lordship.
Well, this is an appeal, my lord, where the question of settlement of a Weighbridge, my lord, is involved.
Yes.
No, my lord. Ask your lordship, I'll just point out, my lord, the rules governing the settlement, my lord, of the Weighbridge. No, my lord, so far the state of Meghalaya is concerned, my lord, they have a set of rules, my lord, Meghalaya Weighbridge rules, installation of Weighbridge rules, 2009. Notified in the year, my lord, 2009. I'll kindly take your lordship to that rule, page 56, my lord. My lord, it starts from page 57, your lordships. My lord, the relevant rule is Rule 3, my lord. May I read it here, my lord? At page 57, my lord. Relevant rule is Rule 3.
Yes.
Madam, I'll just read it. Rule 3, installation of weighing device. The government may install and maintain by itself as many weighbridges for the purpose of section 144 of the Act on such places as it may think necessary, or may allow any private party, person, body or person, company, organization
to install and maintain such weighbridges on payment of lease amount to be determined in each case by the government after calling tender, your lordships. So, my lord, it could be done, settled with a private party, also, your lord. Then, provided that no lease shall be granted permission to any private person, body or person, company, organization, unless after fulfilling the criteria as laid down in Rule 4, 5, and 6 of these rules, and permission from the government in Transport Department is obtained. Now, for your lordships, it say no weighbridge without permission. Private person, body or person, company, organization shall not be eligible for obtaining lease permission to run weighbridges unless he has attained the age of 21 years and above, and he has made an application for grant in writing to the Government of Transport Department through Commissioner of Transport, and shall state, my lord, the criteria is. Then, my lord, I will take my lord to Rule 5, how the permission is granted. Rule 5, next page, my lord, 58. Permission for weighbridge at the satisfaction of Commissioner of Transport, my lord. Here the Commissioner of Transport, my lord, trusted with a huge power, my lord. It depends on his satisfaction.
In your point, as I recollect,
my lord,
that first writ was filed,
lordship.
It was stated before the court,
lordship.
Or you understood
lordship,
that the steps were being taken to withdraw the termination notice, and the writ was disposed of accordingly.
No. Well, I think factually, well, I'll just put it straight. There are as many as 3 writ petitions where, my lord, I have referred to 3 writ petitions. Now, here what happened, my lord? The lease was settled with me in 2017 after calling for tender. I was found the most suitable bidder. It was settled and lease agreement was entered into with me in the year 2017 for 3 years. And the same was renewable. The rule itself says, my lord, it is renewable. It was renewable. Now that agreement was executed by, on behalf of the government, by the Commissioner of Transport. Now, my lord, here what happened, my lord, the lease which commenced in 2017, my lord, expired, my lord, 2020, your lordship, December 2020. Now, as per the requirement under the rules, my lord, before the expiry, my lord, I have filed an application for renewal. That renewal application was pending with the government. Now, in the meantime, my lord, because of the COVID outbreak, what happened, your lordships, either there was total disruption or there was some ad hoc arrangement, your lordship. I was granted, my lord, on ad hoc measures, sometime to run the Weighbridge. Then ultimately, my lord, in 2021, your lordship,
yes,
I filed a writ petition, along with 2 other similarly situated persons, my lord. Filed a writ petition. The limited prayer in my writ petition was this, that government has not taken a call on my application for renewal, and for a direction to consider my application for renewal. Now, in that writ petition, my lord, which was registered as writ petition number 2 of 21, my lord, the government filed an affidavit, and that affidavit was, my lord, filed on behalf of Commissioner of Transport and Commissioner and Secretary of the Transport Department. And in paragraph 5 of that affidavit, my lord, they made a categorical statement that we will renew, my lord, favorably. They have used, I'll take my lord to that paragraph, I have annexed. They have made a categorical statement that we will consider it favorably. In fact, we have renewed other weighbridges, and they have named those other weighbridges also. Now, when the matter came of a hearing, my lord, learned single judge, taking into consideration, my lord, the statement made in paragraph 5 of the affidavit, dispose of the writ petition, my lord, with a direction that the consideration for renewal, my lord, will be done expeditiously, my lord, within a period of 1 month. Now, thereafter, what happened, my lord? The Commissioner and Transport, my lord, he initiated necessary process. Initiated necessary process, my lord, for renewal. And ultimately, my lord, renewal was done, and a fresh agreement, my lord, lease agreement was entered into in the year, my lord, May 2022, for a period of 3 years, which was otherwise due to expire, my lord, in September 25. Since then, my lord, on the basis of this renewal, my lord, I was running the Weighbridge, operating the Weighbridge. Now what happened, your lordship? in the early part of the year 2023, they have issued an imprint order, my lord, taking a unilateral decision, my lord, reducing the period of license. The license which was renewed for September till September 25, my lord. Now that without citing any reason, that was reduced to September 23. And that decision was a unilateral decision, my lord, without notifying any reason, without initiating any proceedings, without issuing any show cause, my lord. So being agreed, my lord, I challenge that order, my lord, reducing the terms of my license unilaterally before this honorable court. Now in this writ petition, my lord, the government entered appearance, my lord, they filed their affidavit. Now, my lord, after hearing the, my lord, after some hearing on the interim, your lordship, the court has granted an interim, your lordships. And while the interim order was continuing, my lord, what the transport department did, they had withdrawn that order by which they had reduced the period of license. Thereby, my lord, they have restored the original license, which was to continue till September 25. So in a way, my lord, that writ petition where I have challenged, my lord, this unilateral decision, my lord, reducing the term of my license, that in a way become infructuous. But my lord, when the situation was, my matter was rested at this, your lordship, what happened? The state government, because my lord, this Weighbridge, my lord, has a dual function, my lord. One, under the Motor Vehicle Act, it's check the, my lord, volume of loads carried by the commercial and public vehicles, your lordships. And to check the speed, your lordships. And the other thing is, my lord, in the same check station in the Weighbridge, my lord, on the basis of the weighment certificate issued by the lessee, my lord, the royalty is collected. The state is entitled to royalty for the mineral transported, my lord. So royalty is collected on the basis of the weighment slip issued by the operator of the Weighbridge. So these are twin function, my lord. Both is done, my lord, in the, it is called, my lord, Weighbridge cum check gate. Yes. And the license categorically stipulated, my lord, for the purpose of enforcement of a weighment, your lordship, and collection of royalty, it is mandatory that the enforcement official of the transport department and other department would be permanently stationed in the Weighbridge. Otherwise, I cannot function. But, my lord, while after, my lord, withdrawing that imprint order, my lord, reducing the period of license, what they did, without any notice, without any formal communication, they had withdrawn the enforcement official also, my lord. Thus, my lord, by their action virtually, my lord, they have stopped me from operating the Weighbridge. In this situation, my lord, I filed yet another writ petition. There, my contention is this, that the first writ petition, my lord, where I have challenged reduction of this period, that has become infructuous because they had withdrawn it. But now what they did, they had withdrawn the enforcement official, thereby they have stopped me from operating the Weighbridge, my lord, which is illegal, your lordship, and they have opened a new Weighbridge by the government just 2 kilometers away from my Weighbridge. So I made a twin prayer in the last writ petition. One, withdrawal of the enforcement officials, my lord, that is illegal, and opening of a government Weighbridge just 2 kilometers away from my Weighbridge, my lord, and relocating the enforcement officials there, my lord, is arbitrary. So these were the twin prayers. Now, learned single judge, there also they filed their affidavit, and government has categorically stated, yes, in view of the withdrawal of the reduction of the period of license, withdrawal of that, the first writ petition of my lord, where I have challenged this has become infructuous. It is their stand. Now, the learned single judge, my lord, took up both the cases together. Both the cases together, my lord, and made an inquiry, my lord, how the settlement was made. Now, the finding of the learned single judge is this, that in the year 2021, my lord, when the writ petition was filed, seeking a direction to the transport department to consider my renewal application, now the learned single judge held in that proceeding, court had never passed an order, mandatory orders, directing settlement of the renewal of the license. So ultimately, my lord, the learned single judge held the way the settlement has been made, and the person who signed the agreement on behalf of the government is unauthorized, And in that view of the matter, my lord, instead of declaring the writ petition became infructuous, dismiss both the writ petition. Now, my lord, against this judgment, my lord, I have come before this honorable court. Now, my lord,
Let us see the judgment.
lordship. That starts from my lord, page 301, Annex 7. Shall I read the entire judgment? Start from page 302. My lord, in the findings of the court starts from, my lord, page 311. Shall I, my lord, start reading from 311? Paragraph 10. 311, paragraph 10, my lord, onwards. Heard learned counsel for the parties, this matter from the submission and material place has raised many issues before this court that have to be examined inasmuch as the writ petition number 2 of 21, writ petition number 299 of 23, and the instant writ petition number 8 of 24 being intertwined and interconnected, it has made the dispute between the writ petitioner and the respondents multidimensional. To address the same, it may be useful to first look at the aforementioned 3 writ petitions and the prayers sought therein, as also the order passed by this court in the course of the proceeding and the subsequent orders that followed from the respondents as well as their actions. In the first writ petition number WPC 2 of 21, the writ petitioner had filed the writ petition with a prayer for extension of renewal of the lease, which was due to expire on 6/12/2020. The said writ petition on an affidavit filed by the state respondent, where it was stated that the petitioner was advised to approach the Transport Department for favorable renewal, which was to be considered taking in view Rule 7 of the Weighbridge Rule 2009 and Point 23 of the Meghalaya State Policy for Weighbridge 2018, was then disposed of by order dated 9/5/2022. By the said order, the court directed the writ petitioner to approach the state respondent with an appropriate application which was to be considered within a period of 1 month. Thereafter, by order dated 30/5/22, the Commissioner of Transport, respondent number 3, directed the writ petitioner to pay a renewal fee of rupees 250 by 31/5/2022. Strangely, however, it was recorded in the order that the same was passed in compliance with the direction of this court, when no such direction was ever passed by this court in the order dated 9/5/2022. The order of this court dated 9/5/2022, as well as order dated 30/5/22 of the respondent number 3 being relevant, are reproduced herein below. Now, this is the order, my lord, in 21. 3 writ petitions were taken up together. Now, my lord, it starts at 313, my lord. These batch of writ petition have been filed for renewal and continuation of the existing agreement between the state and the petitioner for running the weighbridge. It appears that the petitioners are still running the weighbridge, and as per the affidavit of the state respondent, as indicated in paragraph 5, the renewal of the petitioner license would be considered in the event an application is submitted before the state respondents. In view of the circumstances and the affidavit as placed, Mr. H.L. Sangraiso, London Senior Counsel for the petitioner, submits that writ petition can be closed. Accordingly, it is directed that the writ petitioners to approach the state respondents with an appropriate application within a week which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of the certified copy of the order. With the above matter direction, this writ petition stand closed and disposed of. Now, my lord, pursuant to this order, my lord, the commissioner's order, next page, there is order dated 30th May 2022. This honorable court, the Honorable High Court of Meghalaya, while passing the judgment in WPC number such and such, dated 9/5/22, has directed the petitioner to approach the state respondent, that is the Transport Department, with an appropriate application within a week, which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of the certified copy of this order. The Office of the Commissioner of Transport, Shillong, thereafter received a copy from the petitioner on 11/5/22, which has been processed and forwarded in original to the Transport Department on 11th May 2022 by the letter number such and such for further action as directed by the Honorable Court. Therefore, in order to comply with the direction contained in the Honorable Court's order, the petitioner is hereby directed to pay the renewal fee of ₹250 by Treasury Challan positively by 31st March 2022 so as to ensure and enable signing of the agreement in respect of the Weighbridge at UPM, Amsarin and Garampani. Now, my lord, the copy to the Deputy Secretary, Government of Transport Department for favor and informations. Now, this is by the Commissioner of Transport, my lord. Now, 11, an agreement has been executed on 1/6/2022 for another 3 years, which was to expire on 31/5/25 between the writ petitioner and the state respondents. And the same was signed by the respondent number 3. That is, my lord, the Commissioner of Transport. Thereafter, this arrangement came to be curtailed by letter dated 14/7/23 issued by the respondent number 3, making the agreement valid only up to 39/23, 39/23, which give birth to the second writ petition being WPC number 299 of 2023, wherein direction was sought for declaring the letter dated 47/23 illegal and further to allow the writ petitioner to deposit the installments for license fees. This court, while examining the matter by order dated 8/12/23, directed the state respondents to produce relevant records and documents in connection with the renewal of the agreement, which were referred to in the renewal order dated 30/5/2022. It is noteworthy to mention herein that in the impugned letter dated 14/7/23, reference has been made to letter dated 39/23, 36, my lord, it should have been some typography, 36, which conveyed the decision of the government with regard to renewal. This is pertinent. This is pertinent in view of the fact that Rule 6 of the Weighbridge Rule 2009, it is the Secretary to the Transport Department who is the competent authority for issuance of permission, in as much as Rule 3 and 4 vast power of installation of weighbridge and permission to grant establishment to private entities with the government. In the intervening period, however, the respondent number 3, by order dated 16/1/24, withdrew the letter dated 14/7/23, but however, thereafter withdrew the official staff stationed at the weighbridge of the writ petitioner, which then led to the instant petition WPC number 8 of 24. Petitioner's complaint by this last writ petition is for direction to the respondents to act in accordance with the renewal agreement dated 1/6/2022. In the factual situation as portrayed above, it is first to be noted that the initial lease agreement was executed on 17/11/2017 for a period of 3 years, which expired on 6/12/2020. As per the stipulation of Rule 7 of the Weighbridge Rule, a permission granted for installation of weighbridge under Rule 6 is renewable after every 3 years. In case of the petitioner, admittedly, the lease agreement permission was expired on 6/12/2020, and on the non-renewal of the permission, WPC number 2 of 21 has been filed. and the same was disposed of by order dated 9/5/2022 with direction as quoted above. The order of renewal dated 30/5/2022, which has been reproduced above, on bare perusal states that the application of the petitioner had been processed and forwarded to the Transport Department for consideration. But in the last paragraph has issued the order of renewal, citing therein that same is in compliance with the direction issued by this court. As observed earlier, there were no direction issued by the court for renewal, but only for consideration thereof. Interesting to note at this juncture is that Commissioner of Transport, as can be seen from the records, the letter dated 25/22, had written to the Transport Department the following letters. Now, this is the letter dated 20th May 2022. From Commissioner of Transport to Deputy Secretary to the Government of Meghalaya. Renewal agreement of such and such. Now, in the next page. In inviting reference to the letter on the subject cited above, I am to inform you that the Honorable High Court of Meghalaya Shillong, by its judgment dated such and such, has directed renew the agreement for the Weighbridge at Amsarin near Sokha Model and giving a specific period within a month, the date of receipt of the certified copy of the order dated 11/5/22, and which was forwarded to the government on the same day. In this regard, government is requested to kindly accord approval for renewal of the government as per the direction of the Honorable Courts Shillong to avoid contempt of the court, etc. Now, next paragraph, minor. The letter dated 25/22 is indeed disturbing in as much as the Commissioner of Transport, for reason unknown, has sought renewal of the agreement by mentioning the renewal was to be granted as per direction of this court to avoid contempt when no such direction was ever passed. Thereafter, the agreement dated 1/6/22, then executed with the said Commissioner of Transport being the signatory on behalf of the respondent. A comparison of the earlier agreement dated 7/12/77 and the new agreement dated 1/6/22 has also revealed certain discrepancies. Suggests it nowhere reflects that the agreement was renewed after due permission as envisaged under Rule 3 read with Rule 6 and 7 of the Weighbridge Rule was granted. In the agreement dated 1/6/2022, it is simply put as follows. The Governor of Meghalaya, represented by the Commissioner of Transport, Government of Meghalaya, Shillong, hereinafter called such and such, of the first part. No declaration exists as recorded in the initial agreement dated 7/12/2017, wherein it has been stated that the licensee was given permission to set up the said Weighbridge by the government. For the sake of convenience, Rule 3, 6, and 7 of the Weighbridge rules are reproduced herein below. 3. Installation of weighing devices. The government may install and maintain by itself as many weighbridges for the purpose of Section 144 of the Act on such places as it may think necessary, or may allow any private person, body or person, company, organization to install and maintain such weighbridges on payment of lease amount to be determined in each case by the government after calling tender, provided that no lease shall be granted permission to any private person, body person, company, or organization, unless after fulfilling all criteria as laid down in Rules 4, 5, and 6 of this rule, and permission from the government in Transport Department is obtained. Next, my lord, Rule 6. Commissioner of Transport to forward the application to the Secretary Transport Department after satisfying himself that application is complete and meets the requirement as laid down in aforesaid Rule 4 and 5. The Commissioner of Transport shall forward the application with all required information to the Secretary Transport for issue of permission. 7. Renewal of permission. Any permission referred to in Rule 6 above shall be renewable every 3 years, and no such permission shall be granted or renewed unless the proposal for the grant, renewal of permission, as the case may be, is accompanied by the certificate issued by the Inspector of Weights and Measures, Government of Meghalaya, as to the accuracy, correctness of the device. Now, to the next paragraph. In this context, reference can be made to the judgment in case of Kamandalang Suyam versus such and such, wherein it has been held that granting of permission under the Weighbridge rules was essential. Para 26, 37, and 44 being relevant are quoted herein below. What is, however, paramount importance to note is that unless permission was granted under the executive instruction aforementioned or is granted under rule of 209, the question of Weighbridge being installed or operated by a party does not arise at all. Granting permission under 209 rules 2 is therefore sine qua non for installation, operation of the Weighbridge, and consequently a lease cannot be granted unless permission is granted, or a lease cannot be renewed unless a permission itself is renewed. 37, the meeting also resolved that the permission for setting up check gates on national highway should henceforth be given only with the recommendation of the state government and not from the head of the...
What is the relief now you are wanting?
My lord?
What is the relief now you are wanting?
I am asking for, my lord. I filed, my lord. Initially, I have challenged, my lord, the decision of the conveyed to me unilaterally, reducing the term of my license. So that was under challenge. I was given some interim protection. During the subsistence of that writ petition, what happened? They had issued an order, withdrawn that impugn order, my lord, reducing the term of my license. So matter ended there, my lord. So, my lord, I was expecting that I would run now till, my lord, September 25, my lord, which is the original terms of the license. Now what happened, my lord? Immediately after issuance of that order, withdrawing that, what they did, they had withdrawn the enforcement staff also. Now, without enforcement...
And also set up another Weighbridge.
Another Weighbridge, just 2 kilometers away, my lord.
It is a government Weighbridge?
It is a government Weighbridge.
Or license?
No, government, my lord. This is a government Weighbridge. They have set up a Weighbridge. Thereby, virtually, my lord, they have, my lord, make it dysfunctional, my Weighbridge. So, in the situation, my lord, the last writ petition I have filed with a twin prayer, my lord, that their action of withdrawing the enforcement official bad and setting up a Weighbridge 2 kilometers, that is also arbitrary, my lord. This was my prayer. Now, learned single judge, and they also admitted that the writ petition where I challenge reduction of the period has become infractuous. They made a categorical statement in their affidavit.
I have not made any such statement, my lord.
Well, I have not, let me come. The order, it is not, my lord. I'll point out, my lord. They have said it's become infractuous. Well, I will rely, my lord, on that statement. Now, in the situation, my lord, learned single judge, my lord, he made an inquiry, my lord, and I'll just point out one thing, your lordships. Repeatedly, I let them produce record. There is not a whisper anywhere, my lord. Even till date, there is no whisper.
So even if you succeed,
lordship.
Now the situation is that close by, the government has set up another Weighbridge with the personnel or manpower which were manning your Weighbridge. Earlier, they were supplying this, providing this manpower to run your Weighbridge.
Lordship.
Now they are running theirs.
Lordship.
Now there are 2 Weighbridges side by side.
Lordship.
Suppose you succeed in this race. Now 2 at that distance cannot operate, only 1 can operate.
That will affect me, my lord, badly affect me.
No,
obviously.
that
That's
is-
why I made a prayer.
No, that will, and it might also be against government policy of 2 Weighbridges. Suppose you succeed. Two Weighbridges functioning at close distance, which means that additional manpower they have to supply you, and like some customers will come to you and some customers will go to them. That might not be permissible under the rules. So your remedy, even if you succeed, will be confined to damages. If you succeed.
I'll just, my lord, I'll point out your lordship.
The
On
court
that stretch, government has a policy decision and government has notified, I have annexed that, government has notified their policy decision.
No, you have to understand this, Mr. Counsel, that
lordship.
Here in this case, like a writ of mandamus, you cannot, or specific performance in contract, you cannot follow that.
Lordship.
That demolish the Weighbridge constructed by the government and run the Weighbridge run by the writ petitioners. Like in specific performance, they say that you execute the agreement and register and stamp and register it. You can't get an order like that. Now by passage of time, this has become kind of not possible.
I'll try to satisfy your lordship on this point. These are statutory contract, my lord. In the private,
that warehouse, that Weighbridge will be shut down.
Lordship.
Then the costs and all that they have incurred in setting it up then?
No, my lord, so what happened, your lordship? Because government has notified a policy decision, I have annexed. In that stretch of the highway, they have notified there would be 3 Weighbridges. They have notified and they have named, including mine one. So there is no question, my lord, when you had withdrawn the impugn order and thereafter withdrawing my manpower and setting up another Weighbridge, they goes against, my lord, this is arbitrary against their own policy decision which have been ratified by them.
Then it is also like breach of contract.
My lord, it is also, my lord, my humble submission will be, your lordship.
If you succeed,
Lordship.
breach of contract,
My
there
lord,
damages, but
my
you
lord,
can't,
here, my lord,
you
what I-
can't demolish one Weighbridge set up by them and.
My lord, in this case, my lord, what I will ask for, your lordship, you, my lord, bring back the enforcement official to my Weighbridge. Allow me to operate, my lord, till my terms. Do that, your lordship. So this is a statutory contract, your lordship. It's not, my lord, the entire thing in the private domain, your lordship, that I ask for them. Their action has to be fair, my lord. They cannot treat the citizen like this, your lordships. So, my lord, I will just, my lord, point out all those notification, their policy decisions.
On the next day, Mr. Counsel,
When your lordship.
tomorrow, we will hear it.
Yes, we can continue. I will continue.
Tomorrow, some difficulty, my lordship may have it on
Monday.
1 week, after 1 week.
Monday?
Because some
It
puja
can be
will
next.
take. Lordship may have it on 16th, 17th, both days. 16th, 17th, we will finish it. Subject to my friends.
After the Guru Nanak birthday break.
16th, 17th.
16, 17 Saturday.
Oh, sorry, this is, I'm sorry, 17, 18, 18, 19, 18, 19. But I was seeing December calendar, 18, 19.
Monday, Tuesday. 19.
Yes.
All right.
List this appeal for further hearing on 19th.
Great, my lord.
That's it.